Before we begin, we want to make sure that both parties can hear us, as well as each of the parties present today hear and see us. Let's start with the initiating party, Mr. Hall. Can you hear and see both mediators in each party? Now, how about Miss Mary McIntosh? Can you hear and see both mediators and the other party? Perfect. Everyone can hear and see each other. That's a great start. Today, we have blocked off 4 hours for mediation. Now, does either party have any time restraints, requirements, or special needs for today's online mediation? Let us know. We'll write them down and accommodate them both. Further, Mr. Hall, are you one of the decision makers today, meaning you are Charlie's father, correct? And have filed a petition to officially establish visitation rights for Charlie with the court and address the matter over Charlie's education and your concerns about it. Last, you need to grab anything such as a drink of water before we officially begin the mediation. Now, Ms. McIntosh, are you the primary residential parent for Charlie? Okay, good. First, I would like to thank you both. We would like to thank you both for completing our mediation agreement form. Establishes a few things, and it's easier to know what we'll be doing today. We have also received the documents for the petition, as well as both of your emails confirming your current parenting agreement, as well as the main concern over Charlie's education stemming from his learning disability. Are there any other documents that I haven't received or further information that isn't here with you today? And what is Charlie's learning disability? Okay. Now, are all cell phones and pagers off? If not, please do so now so there's no interruptions and we can continue our session. And also, there will be no recording of today's session for confidentiality purposes. No party, nor myself, nor my co-mediator, Brock, can record today's mediation. Do we have permission from both parties to take notes? Handwritten or typed? Okay, welcome to mediation. My name is Garrett Kaplan. I will be one of your co-mediators today.
My name is Brock Gates. I will be your other co-mediator.
To ease any anxiety that either party may have, we'll be asking both parties, starting with Mr. Hall, an icebreaker. Mr. Hall, what is your favorite restaurant to eat at, and what is your favorite movie? Ms. McIntosh, what is your occupation and an activity that you like to do? Further, we want to ask each party, starting with Mr. Hall, to briefly explain why they chose mediation. Okay, now how about the other party? Okay, so neither of you today have a disagreement to the parenting schedule. Mr. Hall just wants to make sure that he can see Charlie and put his potential fears, anxiety, and stress to bed. The contention today, as both of you are letting us know, is Charlie's education and how to proceed. Is that correct? Okay. Are both parties good with using Zoom as an online mediation space today? Okay, good. Okay, so the advantages of mediation over going to court. Mediation is becoming a more respected and used practice in the law field. My mentor had a huge success rate, resolving 203 out of 207 cases. Mediation is a time and money saver. It could be years and tens of thousands of dollars before the judge gives a solution to a matter. When you go to court, you're rolling the dice every time. A judge can decide whatever he or she wants. It might be how they are feeling on that day. It is not always the most reasonable solution. Mediation gives the parties a voice. Today is about both of you. Feel free to speak about your thoughts, issues, and feelings about the case today. You don't have lawyers here, so you'll be speaking from the heart today, which is great. Resolving at mediation takes away any uncertainty of what's to come. The human mind dislikes uncertainty of what could happen or should happen. Uncertainty breeds anxiety, stress, and anxiousness. No one likes uncertainty. If you knew the numbers to the Powerball lottery, then you would always play them. Without certainty, we as humans feel uneasy. Coming to a resolution today can give you certainty that you wouldn't have in the courtroom or the effects afterwards. And now handing over to my co-mediator, Brock.
Hi, folks. As I said earlier, my name is Brock. So first and foremost, I'm going to kind of go over your rights here in mediation. As my co-mediator Garrett talked about earlier, that mediation is confidential. Let me explain to you a little bit about what that means. Nothing said here, no offers made here, or anything that's done here may be used in the court later if there's no settlement reached. Mediation is voluntary. Keep this in mind. So mediation goes for as long as you let it go. If you decide it doesn't work out, you want to walk away, that's your prerogative. Nothing's forcing you to be here. It's absolutely on your own behalf. Nothing set in, and again, nothing set in stone until you sign something. So you have the final say here. As I said, this is confidential. So if you do take notes, I ask that you properly dispose of them at the end of this. I'm asking you, I guess, out of confidence that you'll do so. And again, that goes to the bit about confidentiality. We want to make sure that everything stays between us, and this is kind of a trusting environment. Further, later we'll be breaking off into caucuses, and I'll tell you a little bit about what that is here in a second. But just for now, when we do that, assume that anything you tell me or the co-mediator Garrett, my co-mediator Garrett and I, anything you tell us, we will also tell the other side. So that means everything's confidential so long as you want it to be confidential. There's a certain degree of privacy to everything that's done here, but within the mediation, if you want something to stay between me and you need to let me know you want to sit between me and you. So I'm going to go on to my next point, is talking a little bit about the mediation process. So we start in a group mediation setting, that being us four, Garrett, myself, and then you two. We're going to start together and we're going to kind of talk things out. And after we talk things out a little bit, we'll break off into caucus groups, where we let you kind of tell each individual side, maybe some concerns, maybe some concerns you had with the other party's story as we were talking in our single group, and kind of address maybe the crux of the issue. And so we can boil this out and get it to an agreement. After we hear both sides, we break up into the caucuses. I think it'll be a good chance for all us to have a good understanding of the issue. At that point, we should all really know what we need to narrow in on. And then we'll come together and see if we can hammer out an agreement based on those facts. Like I said, I'm a neutral, or like Garrett has told, we're neutrals. We're not here to make any decisions. We have no authority here. We're not judges. We can't strong arm you into anything. We're just here to help guide your decision-making process. And that's the plain and simple of it. Only you two have the capacity to negotiate and enter this agreement, seeing as that you're not represented by counsel, and of course we do not represent you. You have the final say, and I just can't stress that enough. As far as the agreement goes, if you folks come to terms, I'll draft up and mediate an agreement that reflects those terms. From there, I'll let each of you review the agreement and the provisions to make sure they line up with your wishes. After we review the agreement provisions, if need be, we'll go back and we'll draft and edit accordingly. If not, then from there we can sign an agreement and we will file that with the clerk of courts. And what happens with that is either it gets put into a court's order, or it can be a standalone agreement and taking the place of the court's order, also giving it equal to authority of said order. And again, if we don't come to an agreement, which is completely up to you folks, the court will continue through its normal process. This means that if you don't enter an agreement here, you can either enter an agreement elsewhere, but it's less likely after mediation, and you're more likely to have to settle this at trial. And again, as noted, mediation is a good way to work out the issues prior to trial. It's timely, it's expensive, and you don't always get what you want, and here's the place and the time and the place to kind of work out that detail. With that being said, I'd like to thank you for being here today. As I stated, it's a great opportunity for you to resolve your issues. Before we begin, are there any questions that either you have for me or Garrett going forward? Okay, great. Due to the course of the proceedings, I always start with the plaintiff or petitioner, that being Mr. Hall. Mr. Hall, could you go ahead and please tell me a little bit about what brings you to mediation, the situation, and your growing concerns?